Hey, can you hear me?
Yes, Your Honor.
Okay, we're on the record in the matter of the people of the state of Michigan versus Kyle Neal, file number 22-03342 SM. Council appearance.
Billy Wicks, Assistant Public Defender, on behalf of Mr. Kyle Neal for purposes of arraignment only.
Okay. Mr. Neal, today's the date and time set for an arraignment. I have here before me a misdemeanor complaint. It alleges that on or about November 29, 2022, at the area of 900 LeGrand, which is located in the city of Lansing, Ingham County, state of Michigan, that you did allegedly contrary to law commit the act in count 1 of attempted police officer assaulting, resisting, or obstructing. The allegations that you did make or attempt to commit the following listed offense, and in the attempt did act toward the commissions of that offense, but failed in the perpetration or was prevented in execution thereof, contrary to Michigan Compiled Law 750.92, and that is assault, batter, wound, resist, obstruct, oppose, or endanger Officer Tyler Tenbrink, an officer of the Lansing Police Department, that the defendant knew or had reason to know was performing his or her duties, and that this was done contrary to Michigan Compiled Law 750.81D. That's a misdemeanor, and the maximum penalty is 1 year in jail and or $1,000 in fines. And upon your conviction of any attempted felony, you would be subject to a court-ordered law enforcement DNA collection of identification profiling samples. Do you understand the charge and the maximum penalty there, sir?
Yes, ma'am.
Okay. You have the right to be represented by counsel. Ms. Wicks is here from the Office of the Public Defender to represent you for the purposes of your arraignment only. You have the right to have an attorney with you to represent you at each stage of the criminal prosecution. If you cannot afford to hire your own attorney and you economically qualify, you can request to have an attorney appointed to represent you at the expense of the public. Do you understand your right as to court-appointed counsel?
Yes, ma'am.
Okay. Is he requesting court-appointed counsel?
He is, Your Honor.
Okay, Mr. Neal, you have the right to remain silent. Anything you say and anything that you put in writing can be used against you. You have the right to plead guilty. You can plead not guilty, or you can stand mute. You have the right to proceed to a trial in this matter, and you have the right to have jury trial. At the time of jury trial, you have the right to the presumption of innocence. So that means you are innocent until proven guilty. You have the right to remain silent at trial and not have silence be used to prove or imply that you're guilty. You have the right to see, hear, or question any of the witnesses the prosecution intends to call against you. You have the right at trial to call your own witnesses or present evidence at trial that you believe would further defense to this charge. You have the right to have the prosecution prove each element of the charge being brought against you. They have to prove each element beyond a reasonable doubt. And you have the right to be considered for pretrial release from custody. We'll address your bond in just a moment. Do you have any questions about your rights, sir?
No, ma'am.
Okay. For the purposes of his arraignment, the court will enter a plea of not guilty on his behalf. Is that correct?
Yes, Your Honor. Thank you.
No problem. Mr. Neal, you're currently scheduled for a pretrial conference. It's going to be on Monday, December 12th, 2022 at 11 o'clock in the morning before Judge Stacia Buchanan in courtroom 2. This will be held via Zoom, okay?
Yes, ma'am.
Did you get a copy of the notice to appear in Zoom instructions?
Yes.
Okay. Are you currently employed?
Yes, ma'am.
Where are you employed?
McLaren, Greater Lansing,
What do you do there?
working environmental services.
What's your home address?
6538 Somerset, SOMMERSET, and that's Road.
What's your phone number?
517-894-9932.
Counsel, you can address bond.
Thank you, Your Honor. Mr. Neal has lived in Lansing his entire life. He does have family here in the area. As he's already told the court, he is employed here in the area. He made representations to me that he's not on probation or parole, has no failures to appear, and has no criminal history. For those reasons, Your Honor, we would be respectfully requesting a personal recognizance bond. Thank you.
Personal recognizance bond will be granted. Bond will be set in the amount of $500 personal recognizance. While out on bond, you need to make sure you appear to all of your future court dates, okay, sir?
Yes, ma'am.
Also, while out on bond, you're not to engage in any assaultive or threatening behavior. You're not to use, purchase, or possess drugs or alcohol unless you have a valid prescription. You're not to travel outside the state without prior approval of the court. You're not to possess a firearm or any other dangerous weapon. Do you have any questions about your bond conditions?
No, ma'am.
Any additional matters for the record, counsel?
No, thank you, Your Honor.
Okay, you're all set, sir. Thank you.
Thank you. Have a good day.
Same to you, sir. Is there anyone in there already, or do I need to wait for someone else to come in there?
Everyone except the other Mr. Neal and Mr. Travis are in here right now, ma'am, and Elias Neal will be on his way in right now.
Okay, very good. We're on the record in the matter of the people of the state of Michigan versus Tyrone Howell. I have file numbers 22-03340FY, 18-046120T, 22003250T. Counsel appearance, please.
Haley Wicks, Assistant Public Defender, on behalf of Mr. Howell for purposes of arraignment only.
How are you, Mr. Howell?
How about yourself, Your Honor?
Doing pretty good. Today's the date and time set for an arraignment. I have 3 files for you. Okay, we'll take 18-04617 first. This matter was set for bench warrant because you owe a balance of $245. There was a show cause that was issued by me back on August 17th. You were supposed to appear in court for a show cause hearing on August 29th to explain why you did not make payment on the past due amount. This is a past due amount from a guilty plea back in 2018 before Judge Clark. You failed to appear for the show cause, so a bench warrant was issued. And so you still owe $245. Are you employed, sir?
Yes, ma'am, I am.
Where are you employed?
I work at a meat market.
You work at a meat market?
Yes, ma'am.
What's the name of it?
It is Savon.
Okay. You no longer working at the barber shop?
I do that also.
Okay, so you have more than one job?
Correct, Your Honor.
Okay. When are you gonna pay this $245? Today?
I can pay today.
You can pay today?
Yes, Your Honor.
I'll put here that you'll pay immediately upon release from custody. Okay, file number. Okay, file number 22-03340. I have a felony complaint. It alleges that on or about November 29, 2022, at the area of 5917 South Waverly Road, apartment G, that's in the city of Lansing, Ingham County, state of Michigan, you did allegedly in count 1 commit the act of domestic violence. It alleges that you did make an assault or an assault and battery upon an Ashley Boatcamp and an individual with whom you had a child in common and or an individual with whom you have a dating relationship. that this was done contrary to Michigan compiled law 750.812. Restitution is possible as this offense may have resulted in damage to another individual's property or physical injury or death to another individual. This is a misdemeanor and the maximum penalty is 93 days in jail and or $500 in fines. A consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. However, there is a third offense notice attached to the domestic violence, and it says, take notice that the defendant was previously convicted of assaulting or assaulting and battering his or her spouse, former spouse, an individual with whom he or she had a dating relationship, an individual with whom he or she had a child in common, or a resident or former resident of his or her household, or by knowingly assaulting a pregnant individual by violating Michigan compiled law 750.812 on or about February 26, 2015, and by violating Michigan compiled law 750.812 on or about February 26, 2015. That's the same date twice, and therefore upon conviction will be subject to an enhanced sentence under MCL 750.815. That makes the domestic violence a felony. Maximum penalty would be 5 years and or $5,000 in fines. Again, a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. There's a count 2 of assault with a dangerous weapon, also known as felonious assault. It alleges that you did make an assault upon an Ashley Beauchamp with a dangerous weapon, that being a pistol, but without intending to commit the crime of murder or to inflict great bodily harm less than the crime of murder, and that this was done contrary to MCL 750.82. That's a felony, and the maximum penalty is 4 years and or $2,000 in fines. Your DNA is to be taken upon arrest, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. Count 3 is a weapons felony firearm, and it alleges that you did carry or have on your possession a firearm, that being a pistol, at the time you allegedly committed or attempted to commit the felony, that being felonious assault, contrary to Michigan compiled law 750.227B. That's a felony, maximum penalty 2 years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction. There's a mandatory forfeiture of the weapon or device required under the law. Do you understand the charges are in the maximum penalty attached to each charge?
Yes, Your Honor.
You have the right in this matter to be represented by counsel. You are represented by the Public Defender's Office for the purposes of arraignment only, but you have the right to have an attorney with you at each stage of the criminal prosecution, or if you're questioned by law enforcement. If you cannot afford to hire an attorney, you can request to have court-appointed counsel appointed at the expense of the public. Do you understand that?
Yes, Your Honor.
Is he requesting court-appointed counsel?
He is, Your Honor.
Okay, and Mr. Howell, you have the right to remain silent. Anything that you say and anything that you put in writing can be used against you. You have the right to plead guilty, or you can plead not guilty, or you can stand mute. You have the right in this matter to proceed to a preliminary examination because you are being charged with a felony. You have the right to have preliminary examination within 21 days of today's date, that being your arraignment date. At the time of preliminary examination, you have the right to have the prosecution establish their burden of probable cause. So they need to bring sufficient evidence at the preliminary examination to establish that there is sufficient probable cause that a crime was committed and probable cause sufficient to charge you as a defendant who committed the crime. If this matter proceeds beyond the preliminary examination, you have the right to a trial, and you have the right to a jury trial, or you can waive jury trial and have a non-jury trial. The time of trial, you have the right to the presumption of innocence, so you're innocent until proven guilty. You have the right to remain silent at trial and not have silence be used to imply that you're guilty. You have the right to see, hear, or question any of the witnesses the prosecution calls against you, and you have the right to call your own witnesses or present evidence at trial that you believe would further defenses to these charges. And lastly, you have the right to have the prosecution prove each element of the charges being brought against you. They have to prove each element beyond a reasonable doubt at trial. Do you have any questions about those rights?
No, Your Honor.
You have the right to be considered for pretrial release from custody. We will address your bond at the end of this hearing. Are you, Okay, are you giving me your job? You're still working at the barber shop and then the meat market, correct?
Yes, ma'am.
Do you have any other jobs?
No, ma'am.
What's your home address?
1616 North High Street.
And your phone number?
517-803-0578.
You are currently scheduled for a probable cause conference before Judge Tony Flores. It's going to be on Thursday, December 8th, 2022 at 9:30 in the morning. You have a preliminary examination that's scheduled before Judge Flores, and that's going to be Thursday, December 15th at 9:30 in the morning. Your probable cause conference will be held via Zoom. However, your preliminary examination is in person here at the court. He's located in courtroom 3, okay?
Yes, ma'am.
You get a copy of your notice to appear and the instructions on how you can log in via Zoom. You have the Zoom instructions and the notice to appear? Okay.
Yes, ma'am.
Are you currently on probation or parole?
No, ma'am.
Are you out on bond?
No, ma'am.
You're not currently out on bond before another
Uh,
court?
Not that I know of.
Do you have a pending matter in another court?
Not that I know of, Your Honor.
Okay. File number 22-00235 here says that you have a bond violation, that you have a matter pending before Judge Allen, or at least you were arraigned by Judge Allen is what it looks like. Does that refresh your recollection at all?
Yeah, it was a ticket or some sort. Driving with,
Well, driving while unlicensed or license is suspended is a misdemeanor.
yeah, ma'am.
So that means you would be out on bond on that. Looks like he being Judge Allen gave you a bond, set your bond back on June 10th, 2022. Does that refresh your recollection now?
Yes, ma'am.
Okay, and so the allegations are that you violated the terms of those bond conditions by picking up this new action. You'll be remanded to see a judge in 55th District Court on that matter. I'm not arraigning you on another judge's matter. Okay, so I'll put he's remanded to 55th on that. Okay, counsel, you can address bond.
Thank you, Your Honor. As Mr. Howell has lived in Lansing his entire life, does have family here, is employed in the area. Normally in a case like this, I would be asking for a personal recognizance bond, but as he does have that matter in front of Judge Allen, and it's my understanding that there is also a child support bond on Mr. Howell, I would be asking for a low 10% to allow him to earn credit during this time. Thank you.
Bond will be set in the matter of 10,000, 10%. While out on bond, you're not to have any contact directly or indirectly with the alleged victim, Ashley Bokamp. Do you understand that?
Yes, Your Honor.
You're not to be within 1,500 feet of wherever she lives, works, or goes to school. Is that a problem?
No, Your Honor.
Okay. You're not to possess or purchase a firearm or any other dangerous weapon. You're not to engage in any assaultive or threatening behavior. You're not to travel outside the state without prior approval of the court. You're not to use, purchase, or possess alcohol or drugs without a valid prescription. You're required to report to pretrial services within 48 hours of your release from custody. Do you have any questions about your bond at this time?
No, Your Honor.
Do you understand what indirect contact will constitute? Do you have any questions about the no direct or indirect communication?
No, ma'am.
Okay. Any additional matters for the record today, counsel?
No, thank you, Your Honor.
You're all set, sir. Thank you.
Thank you, Your Honor.
You're welcome. We're on the record in the matter of the people of the state of Michigan versus William Moore, file number 22-03341FY, counsel appearance.
Taylor Wicks, Assistant Public Defender, on behalf of Mr. Moore for purposes of arraignment only.
Okay, Mr. Moore, today's the date and time set for arraignment. I have a felony complaint. It alleges that on or about November 29, 2022, at the area of Washington and Holmes, that's in the city of Lansing, Ingham County, state of Michigan, that you did allegedly in count one commit the act of stolen property, receiving and concealing of a motor vehicle. It alleges that you did buy, receive, possess, conceal, or aid in the concealment of a 2011 Kia Rio, a stolen motor vehicle, knowing or having reason to know or reason to believe that the motor vehicle was stolen, embezzled, or converted, and that this was done contrary to Michigan Compile Law 750.5357. This is a felony. The maximum penalty is 5 years in prison and or $10,000 in fines, or 3 times the value of the motor vehicle, whichever is greater. To impose a fine of 3 times the value, the defendant must either admit the amount or it must be determined by the trier of fact at trial. The court may order reimbursement to the state or local government for expenses incurred in relation to the incident, including but not limited to expenses for emergency response and prosecution under Michigan Compile Law 7691F. Do you understand the charge and the maximum penalty there, sir?
Yes, Your Honor.
Okay. You have the right to be represented by counsel. Ms. Wicks is representing you today from the public defender's office, but she's only representing you for the purposes of your arraignment. If you would like to have court-appointed counsel appointed to represent you at the expense of the public, you would need to make a request for that, or you can retain your own counsel at your own expense. Is he requesting court-appointed counsel?
He is, Your Honor.
Okay. Mr. Moore, you have the right to remain silent. Anything that you say and anything you put in writing can be used against you. You have the right to plead guilty. You can plead not guilty, or you can stand mute. You have the right in this matter to proceed to preliminary examination within 21 days of today's date. At the time of the examination, you have the right to have the prosecution establish their burden of probable cause. So if they need to bring sufficient evidence to establish that there is probable cause that a crime was committed and probable cause to charge you with the crime. If this matter proceeds beyond the preliminary examination, you have the right to a trial. You have the right to have a jury trial. At the time of trial, you have the right to the presumption of innocence. You are innocent until proven guilty. You have the right to see, hear, or question any of the witnesses the prosecution intends to call at trial. You have the right at trial to call your own witnesses or present evidence that you believe would further defense of the charge. And then you have the right to remain silent and not have silence be used against you. Lastly, you have the right to have the prosecution prove each element of the charge against you beyond a reasonable doubt at trial. Do you have any questions about those rights at this time, sir?
No, Your Honor.
Okay. For the purposes of his arraignment, is he pleading guilty, not guilty, or standing mute?
Not guilty, Your Honor.
The court will enter a plea of not guilty on your behalf. You're currently scheduled for probable cause conference on Friday, December 9th, 2022, at 9 o'clock in the morning before Judge Cynthia Ward. You have a preliminary examination scheduled for Friday, December 16th, 2022, at 9 o'clock in the morning before Judge Ward. Your probable cause conference will be held via Zoom. Your preliminary examination will be in person at the court in courtroom 1. Did you get a copy of your notice to appear and the Zoom instructions for Judge Cynthia Ward?
Yes, I did, Your Honor.
Okay. And do you have any questions at this time for the court?
No, Your Honor.
Okay. Are you currently employed, sir?
Yes, I am, Your Honor.
Where are you employed?
Self-employed. Do home
What do you
renovations.
do? Okay. What's your home address?
4220 Pleasant Grove.
And your phone number?
517-256-8694.
Are you currently on probation or parole?
No, Your Honor.
You can address bond, counsel.
Thank you, Your Honor. Mr. Moore has lived in the Lansing area his entire life. He doesn't have family here in the area. He is employed here in the area. He made representations to me that he's not on probation or parole and has no prior failures to appear. While this is a serious matter, felony matter, it is a non-violent one. And for those reasons, we would be respectfully requesting a personal recognizance bond for this matter. Thank you.
Okay, bond will be set in the amount of $2,000 personal recognizance. While out on bond, sir, you're not to engage in any assaultive or threatening behavior. You're not to use, purchase, or possess drugs or alcohol unless you have a valid prescription. You're not to travel outside the state without prior approval of the court. You're not to possess a firearm or any other dangerous weapon. You need to make sure you report to court for all of your future court dates. And then you also need to report to pretrial services within 48 hours of release, okay?
Okay, thank you, Your Honor.
Do you have any questions?
I do not.
All right, have a good one. Thank you. We're on the record in the matter of the people of the state of Michigan versus Christian Margosian, file number 22-03231 SM, council appearance.
Taylor Wicks, Assistant Public Defender, on behalf of Mr. Margosian for purposes of the arraignment.
Good morning, Your Honor.
Good morning, Mr. Margosian. Today's the date and time set for an arraignment. You were arraigned by Magistrate Milmore, looks like back on November 18th. You were provided a court date for a pretrial before Judge Cynthia Ward, and it was for you to appear on the 29th. You failed to appear. And then it looks like you now have a PA 53 violation, also known as a bond violation. Okay, one of your bond conditions from Magistrate Millmore's arraignment was that you were not to have any contact directly or indirectly with an alleged victim, Kathy Lip. You were not to be within 1,500 feet of wherever she lives, works, or goes to school. You also were supposed to appear for all your future court dates, and you were also not to be in possession or use any alcohol. You were not to harass, intimidate, beat, molest, wound, stalk, threaten, or engage in any other conduct that would place any of the following persons or child of any of the following persons in reasonable fear of bodily injury, that being a spouse, former spouse, individual with whom you had a child in common, a resident or former resident of your household. The allegations, sir, are that you made violations as to each of those conditions of your bond release, and that more importantly, that there's been an allegation of contact directly with the victim in the underlying matter, Kathy Francine. So you have the right to have a contested hearing on the bond violation. A bond violation constitutes contempt of court, sir. And so if you're found to be guilty of contempt of court, you're punishable with a maximum penalty of 93 days in jail and or up to a fine of $7,500. You understand that?
Yes, Your Honor.
Okay, does he have court-appointed counsel on the underlying matter?
He does, Your Honor. It's Ms. Schroeder.
Okay. For the purposes of his arraignment as to the PA 53 violation, how does he want to plead?
Not guilty.
The court will enter a plea of not guilty on your behalf, and we will have this matter set for a hearing on the PA 53 violation. As to the failure to appear for the pretrial, that matter has been reset before Judge Cynthia Ward. You now have a pretrial on December 13th, 2022 at 10 o'clock in the morning.
Yes, Your Honor.
Okay. You can address bond counsel.
Thank you, Your Honor. Mr. Margosian did let me know that he this morning thought today was the 29th. And that was why he did not appear yesterday, is he had just simply gotten his dates mixed up. He did let me know that he is going to CMH to do his check-in. He's working on getting Section 8. And for those reasons, Your Honor, we would be respectfully requesting a reasonable bond in the file. Thank you.
Okay, I can understand and mix up in the dates between the 29th and the 30th. However, there is an allegation or allegations of multiple violations to a bond that was just set on the 18th. More importantly, allegations of violation of the no contact order. So bond will be set in the amount of 1,010% with GPS tether. I'm going to reiterate, you're not to use, purchase, or possess drugs or alcohol unless you have a valid prescription. You're not to be within 1,500 feet of wherever Kathy Lip lives, works, goes to school, food shops, goes to the park. You're not to be near her at all. Do you understand that?
Yes, Your Honor.
You're not to have contact indirectly or directly. So direct communication is what we're doing now. You can't do that. Indirect communication would be sending her a letter or sliding into her DMs or sending her a smoke signal or flying a kite by her house with a message. You get where I'm going?
Yes, ma'am.
You can't do that.
Yes, Your Honor.
Do you have any questions about the no contact order?
No, Your Honor.
Okay, bond again set at 1,010% with GPS tether. And then don't forget you have court before Judge Ward, December 13, 2022 at 10:30 for this PA 53 violation and for your pretrial. Any additional matters for the record?
No, thank you, Your Honor.
Okay, you're all set, sir.
Thank you, Your Honor.
Thank you. Did you say Elias Neal was in there?
Yes, ma'am.
Okay. We're on the record in the matter of the people of the state of Michigan versus Elias Neal. This is file number 22-02679 FY. Council appearance.
Haley Wicks, Assistant Public Defender, on behalf of Mr. Elias Neal for purposes of arraignment only.
Okay, Mr. Neal, today is the date and the time set for a arraignment. I have a felony complaint. It alleges here that on or about April 23rd, 2022 at the area of 900 LeGrand Drive, that's in the city of Lansing, Ingham County, state of Michigan, that you did allegedly in count one commit the act of assault with a dangerous weapon. That's also called a felonious assault. It alleges that you did make an assault upon a Megan Dibble with a dangerous weapon, that being a pistol, but without intending to commit the crime of murder or to inflict great bodily harm less than the crime of murder. This is contrary to Michigan Compile Law 750.82, and that's a felony. The maximum penalty is 4 years and or $2,000 in fines. Your DNA is to be taken upon arrest, and a consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement. There's a count two of assault with a dangerous weapon, also a felonious assault. And again, it alleges that you did make an assault upon a Keegan Dibble Darty with a dangerous weapon, that being a pistol, but without intending to commit the crime of murder or to inflict great bodily harm less than the crime of murder. And that this was done contrary to MCL 750.82. Again, that's a felony. Maximum penalty is 4 years and or $2,000 in fines. Your DNA is to be taken upon arrest, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. There's a count three of assault or assault and battery. It alleges that you did make an assault or an assault and battery upon the person named Mason Watkins, contrary to MCL 750.811. That's a misdemeanor. Maximum penalty 93 days in jail and or $500 in fines. Again, a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. Also, restitution may be ordered for the assault and battery, as this may have resulted in damage to another individual's property or physical injury or death to another individual. Do you have any questions about either of those charges, or do you understand the maximum penalty to each charge?
Ma'am.
Okay, you have the right to be represented by counsel. You have the right to have an attorney with you to represent you at each stage of the criminal prosecution, or they to be with you if you are questioned by law enforcement. If you cannot afford to hire an attorney, you can request to have court-appointed counsel appointed at the expense of the public. Do you understand that?
Yes, ma'am.
Okay, are you a little tired?
Yes.
Okay, well, you need to stay awake for an arraignment. This is important information for your benefit, okay? Okay, very good. Okay, very good. Okay, you have the right in this matter to proceed to a preliminary examination. You have the right to have preliminary examination within 21 days of today's date. At the time of preliminary examination, you have the right to have the prosecution put on sufficient evidence to establish that there's probable cause that a crime was committed and probable cause to charge you with the crime. Do you understand those rights?
Yes.
If this matter proceeds beyond preliminary examination, you have the right to have a trial. You can have a jury trial, or can I help you? Okay. If this matter proceeds beyond a preliminary examination, you can have a jury trial. You have the right to a jury trial, or you can waive it and have a non-jury trial. At the time of trial, you have the right to see, hear, or question any of the witnesses the prosecution intends to call. You have the right to the presumption of innocence at trial, so you are innocent until proven guilty. You have the right to have each element of the charge being brought against you being proved by the prosecution beyond a reasonable doubt at trial. You have the right to remain silent at trial and not have silence be used against you. You have the right to call your own witnesses to trial or present evidence you believe would further defense to the charge. You also have the right today to plead guilty. You can plead not guilty, or you can stand mute, and we'll proceed to the next stage of the criminal prosecution. And then lastly, you have the right to be considered for pretrial release from custody. Do you have any questions about any of the rights that I just listed to you?
No, ma'am.
For the purposes of his arraignment, is he pleading not guilty?
Yes, he is, Your Honor.
And is he requesting court-appointed counsel?
He is.
You're currently scheduled for probable cause conference before Judge Stacia Buchanan Thursday, December 8, 2022 at 9:30 in the morning. That'll be via Zoom. You should have received Zoom instructions along with your notice to appear. You have a preliminary examination before Judge Buchanan. That's going to be December 15th, 2022 at 10:30. That's going to be in person before Judge Buchanan in courtroom 2. You got your notice to appear, sir?
Yes, ma'am.
Okay, are you employed?
Yes.
Where are you employed?
Riverview Estates,
What do you do there?
maintenance,
What's your home address?
900 LeGrand Drive.
What's your phone number?
517-721-9438.
Are you currently on probation or parole or out on bond?
No, ma'am.
Do you have a matter pending before the 29th Circuit Court?
Yes.
I just asked you if you were out on bond.
Oh, I'm sorry. Yes, I am.
Okay.
Oh,
You can address bond, counsel.
Thank you, Your Honor. Mr. Neal has lived in the Lansing area his entire life. He has family here in the area. He has long-term employment here in the area. As he made representations to the court, he is not on probation or parole and has no prior failures to appear. Normally, in this case, I would be asking for a personal recognizance bond, as proper bond conditions could protect the complaining witnesses. However, it is my understanding he has a no bond hold out of Clinton County, and therefore I would be asking for a 10% bond for him to accrue credit on this file. Thank you.
Okay, we have serious allegations here, allegations of assault against 3 victims, and 2 of which assault allegedly haven't had taken place with a felonious weapon, that being a pistol. Also, in looking at his prior criminal history, it's apparent to the court that he would have been on probation during the time of this alleged incident. So personal recognizance bond would not be appropriate in this matter. I also think that there's a threat to the public safety and to the community. Bond will be set in the amount of $10,000 cash surety with GPS tether. While out on bond, you're not to engage in any assaultive or threatening behavior. You're not to use, purchase, or possess any drugs or alcohol unless you have a valid prescription. You're not to have any contact with the alleged victims in this matter. That being Megan Dibble, Keegan Dibble Doherty, and Mason Watkins. You're not to have contact directly or indirectly with any or either of them or any of their family members. You're also not to be within 1,500 feet of wherever they live, work, or go to school. Not to travel outside of the state without prior approval of the court. You're not to possess a firearm or any other dangerous weapon. I'm going to order that while out on bond, that you participate in urine analysis testing. You need to report to pretrial services within 48 hours of release from custody. Do you have any questions today?
Oh,
Okay, any additional matters for the record, counsel?
No, thank you, Your Honor.
You're all set, sir. Okay, do we have Lance Travis there yet?
He is on his way in. It'll be about 30 seconds, ma'am.
Okay, perfect. Oh, I think I forgot Mr. Tuttle. Is Mr. Tuttle there?
Yes, ma'am, he is.
Okay, we're on the record in the matter of the people of the state of Michigan versus Joseph Tuttle, file number 22-03339 SM, council appearance.
Taylor Wicks, Assistant Public Defender, on behalf of Mr. Tuttle for purposes of arraignment only.
Okay, Mr. Tuttle, today's the date and time set for arraignment. I have here a misdemeanor complaint. It alleges that on or about November 29, 2022, at the area of 3612 West Miller, Apartment H, City of Lansing, Ingham County, State of Michigan, that you did allegedly in count one commit the act of malicious destruction of personal property, $200 or more, but less than $1,000. The allegation is that you did willfully and maliciously destroy or injure tires, door, camera, and personal property of a Jade Wachowski, and that the amount of destruction or injury was $200 or more, but less than $1,000, contrary to Michigan compiled law 750.377A1CI. That's a misdemeanor. The maximum penalty is 1 year and or $2,000 in fines, or 3 times the amount of the destruction or injury, whichever is greater. Do you understand the charge and the maximum penalty attached to the charge?
yes, ma'am.
You have the right to be represented by counsel. Ms. Wicks is representing you today just for your arraignment, but you have the right to have an attorney represent you throughout the entire criminal prosecution, or if you are questioned by law enforcement. If you cannot afford to hire your own attorney, but you economically qualify, you can request to have court-appointed counsel appointed to represent you at the expense of the public. Do you understand that?
Yes, ma'am.
Okay, are you requesting court-appointed counsel?
Yes,
Okay, and then Mr. Tuttle, you have the right to remain silent. Anything that you say and anything you put in writing can be used against you. You have the right to plead guilty, you have the right to plead not guilty, and you have the right to stand mute. You have the right in this matter to proceed to a trial, and you have the right to have a jury trial. At the time of trial, you have the right to the presumption of innocence, because you are innocent until the prosecution proves you guilty beyond a reasonable doubt. You have the right to remain silent at trial and not have silence be used to imply or to prove that you're guilty. You have the right to see, hear, or question any of the witnesses the prosecution intends to call. You have the right to call your own witnesses at trial or present evidence that you believe would further defense to this charge. You have the right again to have the prosecution prove each element of the charge being brought against you, and they have to prove each element beyond a reasonable doubt. Do you have any questions at this time about your rights?
no, ma'am.
Okay, for the purposes of his arraignment, he's pleading not guilty, correct?
Yes, Your Honor.
Okay, The court will enter a plea of not guilty on your behalf, sir. You're currently scheduled for a pretrial conference before Judge Stacia Buchanan. It's gonna be Monday, December 12th at 10:30 in the morning. That'll be via Zoom, okay, sir?
Yes, ma'am.
Did you get your notice to appear in the Zoom instructions?
Yeah, yes.
Okay, very good. Are you employed, sir?
Actually, I start work tomorrow.
Okay, where's that?
Subcontractor through, Hayes, Home Improvement.
What's your home address?
1560, Eiffel Road. Lot number is 39. Polk,
You
Michigan.
said 1516 what?
1560, Eiffel, Polk, Michigan.
What's your phone number?
Well, currently I don't got one because my phone was under the other person's account, so I'm pretty sure I don't got that no more.
Okay, sounds good. Are you currently on probation or parole?
Oh, ma'am.
You can address bond counsel.
Thank you, Your Honor. Mr. Tuttle has lived in Lansing his entire life. He does have family near in the area. As he made representations to the court, he is not on probation or parole. He made representations to me that he has cleaned up any prior failures to appear that he may have had. For those reasons, Your Honor, we would be respectfully requesting a personal recognizance bond in this matter. Thank you.
Bond will be set in the amount of $1,000 personal recognizance while out on bond. Mr. Tuttle, you need to appear in court for all of your court dates. We don't just want you to clean them up. We want you to appear when you're supposed to be there, okay?
Yes, ma'am.
Okay, and there's a no contact order that will be put in place for the protection of Jade Weskowski. You're not to be in contact directly or indirectly with Ms. Weskowski. Doesn't sound like that will be much of a problem since you don't have a phone at this time. But you
No,
don't
ma'am.
want to be within 1,500 feet of wherever she lives, works, goes to school, or parks her car, okay?
Yes, ma'am.
Also, while out on bond, you're not to engage in any assaultive or threatening behavior. You need to make sure that you're not using or possession of alcohol or drugs without a valid prescription. You're not to have a dangerous weapon or a firearm. You're not to travel outside the state without prior approval of the court. Do you have any questions at this time about your bond conditions?
No, ma'am.
Any additional matters for the record, counsel?
Thank you, Your Honor.
You're all set, sir. I mean, why not? It was a kind of a little joke, though. It's so literal. But can you check the spelling? I don't know if I spelled that street right. You know what I mean? Okay, we're on the record in the matter of the people of the state of Michigan versus Lance Travis, file number 22-02526FY. Appearance for the record.
Taylor Wicks, Assistant Public Defender, on behalf of Mr. Travis for purposes of arraignment only.
Okay, Mr. Travis, state the date and time set for an arraignment. I have a felony complaint. It alleges that on or about September 2nd, 2022, at the area of 5929 South Waverly, Apartment C, City of Lansing, Ingham County, State of Michigan, that you did allegedly in count one commit the act of assault with intent to do great bodily harm, less than murder, or by strangulation. It alleges that you did make an assault upon a Tiffany Bonilla and by strangulation or suffocation contrary to MCL 750.84. This is a felony and the maximum penalty is 10 years in prison and or $5,000 in fines. Your DNA is to be taken upon arrest. And a consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement. There's a count 2 of domestic violence. It alleges that you did make an assault or assault and battery upon a Tiffany Bonilla, an individual with whom you had a dating relationship contrary to Michigan Compile Law 750.812. That is a misdemeanor, maximum penalty 93 days in jail and or $500 in fines. A consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. Restitution may also be ordered in the domestic violence charges. This offense may have resulted in damage to another individual's property or physical injury or death. Do you understand the maximum penalty in each charge that was just read to you?
Yes, ma'am.
You have the right to be represented by counsel. You have representation from the public defender's office today for the purposes of arraignment only. You have the right to have an attorney with you to represent you at each stage of the criminal prosecution. If you cannot afford to hire your own attorney, but you do qualify, you can request to have an attorney represent you at the expense of the public. Do you understand that?
Yes, ma'am.
Is he requesting court-appointed counsel?
Yes, Your Honor.
Okay, Mr. Travis, you have the right to remain silent. Anything you say and anything you put in writing can be used against you. You have the right to plead guilty. You can plead not guilty or you can stand mute. You have the right to proceed in this matter to a preliminary examination. You have the right to have preliminary examination within 21 days of today's date. At the time of preliminary examination, you have the right to have the prosecution meet their burden, which is probable cause. They have to establish at preliminary examination that there is sufficient probable cause that a crime was committed and probable cause sufficient to charge you as the defendant in the crime. If this matter proceeds beyond the preliminary examination, you can proceed to trial. You have the right to a jury trial in this matter. And at the time of jury trial, you have the right to the presumption of innocence. You are innocent until proven guilty. You have the right to be represented by counsel at trial. You have the right to remain silent at trial and not have silence be used to imply or prove that you're guilty. You have the right to see, hear, or question any of the witnesses the prosecution calls against you. You have the right to call your own witnesses to trial or present evidence at trial that you believe would further defense to the charge. You have the right to have the prosecution prove each element at trial beyond a reasonable doubt. Do you have any questions about those rights at this time?
No, ma'am.
You have the right to be considered for pretrial release from custody. We'll address your bond at the end of this hearing. For the purposes of his arraignment, how is he pleading?
Not guilty.
The court will enter a plea of not guilty on your behalf. Are you currently on probation or parole?
No.
Okay, you're currently scheduled for probable cause conference before Judge Tony Flores on December 8, 2022, which is a Thursday at 9:30 in the morning. That'll be via Zoom. You have your preliminary examination scheduled at this time before Judge Flores. That'll be in person at the court Thursday, December 15, 2022 at 9:30 in the morning. Do you have your notice to appear, sir, and your Zoom instructions?
Yes, ma'am.
Very good. Are you employed?
No, not currently.
Oh, okay. How do you pay your bills?
I have side jobs or go with my uncle to work.
What's your home address?
16400 Upton Road, East Lansing, Michigan.
That's not the address. You give me that again?
16400 Upton Road, East Lansing, Michigan.
Okay, what's your phone number?
517-388-5516.
You can address bond counsel.
Thank you, Your Honor. Mr. Travis has lived in the Lansing area most of his life. He does have family here in the area. He's already made representations. He is not on probation or parole. He made representations to me that he has no prior failures to appear and no assaultive criminal history. With proper bond conditions, the complaining witness in this file can be protected. For those reasons, we would be respectfully requesting a personal recognizance bond in this matter.
Okay, bond will be set in the amount of $2,500 personal recognizance. While out on bond, there is a no contact order in place for the protection of the alleged victim, Tiffany Bonilla. You're not to be within 1,500 feet of wherever she lives, works, or goes to school. Do you have any questions about that?
No, ma'am.
You have to have communication or contact with Miss Tiffany Bonilla, not directly or indirectly. So no contact of any kind, neither through yourself or through a third party or other entity. You understand that?
Yes.
Okay. While out on bond, you're not to engage in any assaultive or threatening behavior. You're not to use, purchase, or possess drugs or alcohol unless you have a valid prescription. You're not to travel outside the state without prior approval of the court. You're not to possess a firearm or any other dangerous weapon. You need to report to pretrial services within 48 hours of your release. You'll be reporting to them weekly, okay?
Yes.
Do you have any questions at this time regarding your bond conditions?
No.
You need to make sure you appear to court on time for all of your future court dates. Unless you have any questions for me or there any additional matters from the council, you're all set.
Thank you.
Thank you.
Thank you, Your Honor. I believe that concludes arraignments for this afternoon.
Thank you. Have a good one.
You as well. Thank you.
Thank you for accommodating our rotating room full of people, ma'am.
No problem. Thank you. Ms. Cooper. Are you there, Ms. Cooper?
Yes, I'm here, Your Honor.
How are you, ma'am? Can you hear me?
Yes, ma'am.
I was asking, how are you?
Oh, I'm well. I'm well, thank you. How are you?
I'm doing well myself. Your matter was actually dismissed, so you're all set.
Oh, look at God. Thank you.
Yes, look at it. You're welcome, ma'am.
Thank you so much.
You have a good one.
You too.
Okay, nobody is here until 2:30, correct? Is anybody in the hallway? What's your name?
So Kayla Saldana?
What's your name?
My name is Carrie.
Carrie, last name? Kim? Okay, so you all are here on the same matter. Okay. No one by the name of Kiania Pringle present out there? Mr. Dax? You all can be seated. You're muted.
Sorry, Your Honor,
They
I was still in Judge Buchanan's courtroom finishing up. Sorry.
Oh, no problem. Did the
I'm all
defendant
good now,
vacate the
though.
property?
No, both of them are still there.
Okay, well, they
According to my
failed to
client.
appear. This matter was set for 2:30. It's 2:45. You can request default.
Thank you. Which case did we start with, Your Honor?
I was just on your one for 2:30. You only had one. Last name
Oh.
Pringle?
I have Pringle and Scott.
That's
Oh,
at
that's at 3
3 o'clock.
p.m. Okay.
Yep. So you don't need to put it on the record. You can just submit your default request to Judge Simmons Courtroom at lansingmi.gov.
Thank you.
No problem. Okay. Carrie Kim, you take that side. And Kayla Sedona. That's right. On the record in the matter of Carrie Kemp versus Kayla Sedona, file number 22-021556 GCE. Please state your name for the record.
Carrie Kemp.
State your name for the
Kayla
record.
Saldana.
Okay, neither of you have an attorney, correct? This is a date and time set for a motion for possession pending judgment. You could take your seat if you'd like. It looks like there is a request. Plaintiff alleges they're lawfully entitled to the possession of the following property, being 5 sugar gliders, 2 chinchillas, and 2 dogs. The allegation is that the defendant claimed to have sold the animals several times. Is that what you're saying? Is that a yes? I have a
sorry.
record. Thank you. You have to say it verbally so she can pick it up. It says fails unless changing amount of money is paid. Am I reading that right?
It's defendant failed to give animals back unless an amount of money was paid.
Okay. So there's an underlying lawsuit. Complaint, you're suing for estimated value of $1,500
For the animals not returned, yes.
for the animals that are not returned.
That was recommended to me.
Was there a loan of animals?
No, so I motioned for possession of the animals, and because I knew she was actively selling them, they told me to also put an amount if I did not get all the.
I recognize that. I'm trying to figure out why you think that she owes you these animals or money for them.
Because they would have been sold under her care without consent.
So you're saying you own the 5 sugar gliders,
Yes.
you own the 2 chinchillas and 2 dogs, is what you're
Yes.
alleging.
Yes.
Why do you believe you own them?
Because, I mean, I don't know if you want me to go into my story.
I just need a little bit of it because I'm trying to understand why I would grant possession pending
Sure.
judgment.
I left a domestic abuse. I ended up coming to Michigan. I was accepted by a program, and in that stance, I could go into a shelter and then into transitional living and then on my own. In order to do that, though, I wasn't allowed to bring the animals with me.
To the
And so-
program, you mean, or to
Right.
the, okay,
So I contacted shelters. I've contacted a list of names that the organization gave me, and Kayla stood up to helping in this situation.
okay, so you entrusted her, your allegations that you entrusted her with temporary custody of your animals?
Yes, until I was on my own.
Was that in writing of some sort?
Yes, my phone busted, and so I don't have that writing anymore, unfortunately.
Okay, and was there a time period that she was supposed to be in custody of these animals?
No. It was
Just an indefinite,
completely communication based.
just for an indefinite period of time?
Mhm.
Is that a yes?
Yes,
Were you supposed to pay any money for that?
that was not agreed upon. I did agree though to give, sorry. I did agree to pay for their food items. I gave their cage. And any items they needed. Kayla was welcome to contact me for any food or cage items, necessities needed.
Okay, and so you are suing for possession of the animals or what you believe would be a reasonable value, estimated value of $1,500. And so you believe or have reason to believe she's sold those animals?
Yes,
Okay,
I'm missing 3 sugar gliders and 2 chinchillas.
it says 5 sugar gliders on
Yes,
here.
I received 2 sugar gliders back and 2 dogs back.
So you're looking to amend your complaint.
That's fine, yes.
So you received how many sugar gliders back?
2,
So you're missing,
3.
okay, and what about the 2 dogs?
I got the 2 dogs back. I'm missing the 2 chinchillas.
Okay, so now there's just 3 sugar gliders and 2 chinchillas.
Yes.
And so would that should reduce the $1,500,
Yes.
correct, to
Yes.
what?
Um,
Because I don't know how much a sugar glider is.
That's okay. So chinchillas can go from $100 to $400.
What is a sugar glider? Because I don't even know.
It's like a chipmunk
Okay,
squirrel mix. It's a marsupial and it has like little wings. From my breeder that I got the 3 sugar gliders was $750 in total for all of them. And I wish I could have printed that for you so you have that on record. And then with just basic research, chinchillas, I paid $150 each for my chinchillas, so that'd be $300.
so let me see. You said you originally purchased the 5 sugar gliders for $750?
No, I purchased the 3 that she had sold.
Oh, those were $750 by
Yes,
themselves?
that's correct.
Okay, and then the
2
chinchillas?
was $150 each. Which was a deal because I was supposed to pay $200.
So now you're seeking a recovery of $1,050, is that correct?
That's correct.
Okay, let me see. Your turn.
As Ms. Kim said, there actually was a timeline into which I was to have fostering the animals. I do have that documentation that she cannot provide, based off as a Facebook post.
So you mean there was a post looking or seeking someone to take temporary
Correct, and I
custody?
responded to her post.
Okay, and it was,
In that post,
what was the time frame?
it was until May, so it's 4 weeks. So April to May is 4 weeks.
Okay,
In that
this
post-
year?
Yes,
Okay, so you had it from April until May? Is that
that's
what you're
not
saying?
correct. I've actually had them for 7 months.
So you got them in April?
Yes. Let me double
So
check. the
when did
months.
you,
I'm
I was
sorry,
gonna say,
I'm
when
having
did you
like a
sell
little
them
bit
then?
of-
Because this complaint was filed, I believe.
I got them in May. I'm sorry, excuse me. So I had my months. I got them in May. And
And then when did have you sold these animals?
no.
Do you have possession of them?
So the chinchillas she actually gave to me, which I actually have documentation of as well. She gave them to me because she could not care for them because they were too messy, and I actually have that documented. She even posted in a different group and screenshotted it to me saying she was very happy to rehome her chinchillas to me because they were going to a great home. Because she couldn't care for them. So the chinchillas,
Okay, so the chinchillas you're saying were gifted to you,
yes,
and you have proof.
I do.
And then what about the sugar gliders?
So the 2 sugar gliders she did get back. I did rehome, so I will admit fault for that. After a few months of her not providing the proper care for them, after begging, I do have all that documented. I literally begged them if these cages are rusted. I had to go buy cages for them, provide food on numerous occasions for them, for their basic needs, not just their pellets and calcium, but they also they require fruits and veggies and eggs and things like that. Conversations that Carrie and I had, I did rehome them to a very, very familiar person with
What
animals.
does that mean? Oh, someone familiar with animals.
Or with the sugar gliders, yes.
Okay, got it.
Because I had so
I
many
thought
of
you
her,
meant
I had so
familiar to
many,
you.
yes, I had so many of her animals at that point. It had reached a point that I had to make a choice what was best for the animals, and unfortunately, I think I might have made the bad one. I did not make profit off of those sugar gliders, though. They were rehomed, they were not for profit. As far
Okay,
as
when
the
did that happen?
Goodness. I can look in my phone really quick.
Like, let's see the exact date. Was it?
Possibly about 3 months ago.
So you're thinking sometime this summer this happened? Did you rehome them?
Yep, it was fairly recent within the last few months. Yes.
Okay, but your understanding is you were gonna have or house these animals from May until June? Okay, I want to see your evidence of because it sounds like she doesn't have the 3 sugar gliders.
Correct, because I did rehome those 3 sugar gliders. That is
So-
absolutely correct.
There really is no basis to grant possession of the animals pending judgment. I can even give you the money pending it because I now have to determine at the time of the underlying case whether or not you're entitled to recovery. I'm not going to make that determination today, but there's no animals in her possession, as she states here on the record, that are these 3 sugar gliders. She's rehome those, or we'll determine whether or not you're entitled to recovery for that.
Sure.
But sounds like she does have the 2 chinchillas.
No, yeah.
No,
I have one of the chinchillas still, yes.
well,
The
you said
other
that,
one,
but okay, you said she gifted you the 2 chinchillas,
Yep.
and now you only have 1.
and I
Got it.
actually informed her, so she had 3 chinchillas initially. She brought them over to me on my porch. One of them was actually dying, and I have documentation of her asking me to get what's called sparks in it, or spark, I believe is what it's called. It's like veterinarian help. She asked me to
Okay.
take that chinchilla to a vet, and I told her I couldn't afford to. She's like, can you please try to revive this baby? Here's the baby. She showed up on my porch with them and asked me to take care of them. I have that all documented. And then the other one that did not die, I did rehome, because at that point I had like 15 of her animals.
So you don't have any chinchillas in your house?
I have one of them.
You have 1.
I have one of mine, and
Alright.
then one of the ones that she had gifted me. Yes.
Okay, so you're only currently in possession of 1 animal that you were originally to be taking temporary care of from her. Correct. Okay. Show me evidence that you have to support that she gifted you the chinchillas.
Here's this one. It's the screenshot that she actually. Do you want me to bring it up to you?
Nope, he's gonna
Okay.
get it for you.
So this one right here, she said, I thought I'd send you this. Someone asked if they should rehome, and then this is her screenshot that she had posted in the group and sent that to me. That's one of the documents that I have. I also have another one that says I gave you the animals. I literally have a message that says I gave them.
Okay, so is the blue you and the white her?
Correct. Yes, ma'am. I believe so.
Okay,
again, I do have another message that says, instead of paying you, I gifted you the animals. I actually have that. I'm trying to find that right now. I tried to have it all organized.
Okay, this is not giving me the, but where is it that she decided to give it to you?
I'm currently trying to, well, it says, unfortunately, it's very vague. The other message that I have, it says, instead of selling my animals, I gave them to you. I'm currently trying to find that one.
I don't know that that means that she was gifting you the animals. Let's see. I don't even see that. Where is that in here?
That, it's, I'm trying to look for it. That's a whole different message. I'm trying to look at it. Unfortunately, I have a lot of documents here. I'm so sorry. I don't mean to.
Yeah, if I may, while she's looking
Yes,
for the
yeah.
document. She said 7 months. I moved into my apartment on June, July, it's like July 26th, and then I had to get a judgment to get my animals.
You have a judgment for your animals, you mean?
Or to get my,
Oh,
yeah, to get my
got it.
animals. So yeah.
So you moved in June,
Mhm.
well, end of June, almost July, and you started to seek out to try to get your animals then?
It was July 26th, June or July 26th.
Oh, yeah, I see here,
Yeah.
these communications were in July.
Mhm.
Let's see.
Yeah, because August 17th, I was begging for my animals back. And that's when I had to file.
Yeah, see, unfortunately, I did find it, but it is very vague. Once again, it doesn't necessarily deliberately say that she gave me the
Let me see
chinchillas.
what you have here.
Yes, ma'am. It's this one right here. It's the furthest over message. So yeah, unfortunately, I don't have her in message deliberately saying, she did come to my house on numerous occasions. She gave us the chinchilla named Butters because she told us that she couldn't care for them or provide the care for them. My husband as a witness and also my 14-year-old child who's also been caring for them is also a witness to these conversations.
Well, I thought this conversation happened on social media.
No,
Okay.
not all of them.
What does it mean? What you don't know, Kayla, is that some animals have contracts assigned to them?
I don't know what that means.
What does
She
that
said
mean?
that to me.
So again, some of my animals come from breeders, so
Okay.
I cannot keep them. They must go back to the breeder. There's contracts.
Okay.
I did not bring those in because I didn't expect to show
I
them, but
literally gave you a candle, and instead of selling my animals,
I gave them to you. So that's where she was referring
I
to.
give them to you. What does that mean? Well, she's got to
Yeah,
explain that.
sure. So the whole conversation was that Kayla felt that I was not appreciative enough for her. And so she wanted to keep the animals. And I said, I had given you a candle, and I trusted you. I gave you my animals. So I trusted her with my animals.
Got it. Okay, so she means that she entrusted you versus giving as in you could keep.
That is 100% false. The rest of the conversation is in my phone.
I know that me and Kayla spoke on numerous occasions. I really wish my phone wasn't busted, but on multiple.
Well, here's the
occasions,
thing. I know you said that's not the truth, but she says right after that she knows you're upset. You aren't buying them food. If she gave it to you, why is she buying them food?
I'm sorry.
Why was she buying them food?
That
if
was
she gave it
referring
to
to
you?
the other animals. That was not referring to chinchillas. I was referring, I can, again, it's all in my phone. I have the entire thing documented. I did not print out everything. What she is saying is false. Again, based off that message, it's probably not clear context.
Oh, yeah, it's really not.
Yeah,
I need the
I
complete
understand.
conversation
Yep.
if you're gonna,
I
put
mean, I
something
have
like that
my
in
cell
there.
phone here and you are more than willing.
Okay.
There's a lot of messages though, so I'd have to
I'm
wait.
not, at this point, you guys can get this together for the underlying issue, because I think this will help shed light as to whether or not she has any entitlement to recovery, either the money or the animals. At this point, there's only one animal in your possession. I'm not gonna order that it be turned over because I'm not satisfied based on what I've seen here today, which you have the burden of proof, so you would need to tell me or provide something to show that you lawfully had or should have possession of the animal. What we have here, bare minimum from you, is that you did find someone to temporarily home or house your animals in an estimated time period of 4 weeks. Sounds like it was a little bit over that, is what it sounds like.
But we met in
But
person.
it sounds like there was some communication. I don't know what that communication entails. Nonetheless, what I think is appropriate is that now that there's only one animal still there, she can maintain possession of the animal. I'm going to order that you are not to sell or rehome that animal during the pendency of that matter. You're to maintain custody and care appropriate for that animal. And then we will decide the custody of the animal at the time of the underlying matter. All that other information you have there may be helpful as a defense as to whether or not you will owe for the not reasonable value of the other animals that you no longer have in custody. But at this point, the motion to grant judgment or possession pending judgment is going to be denied. In this matter, you did file a complaint. I'm going to construe what you shared today as a motion to amend your complaint, because you did resolve or receive some of the animals back. And so it's going to be amended to now.
So 750 for the sugar gliders, if we're not counting the chinchillas.
750, hold up here. We're gonna get you a new form and let you read amended in a minute. 750, the sugar glider thing, it sounds like, did you, somebody, which was the chinchilla that passed, or one chinchilla passed?
Right.
Correct?
Yes, she asked me.
You're not disputing that the chinchilla passed?
No.
Okay, so where are you getting the 2 chinchillas from?
So there was cocoa, peanut, and butter. And so 30 minutes out the door, noticed Peanuts wasn't doing well. And oftentimes chinchillas will hold illness until the last second of their life. I offered to take Peanuts immediately to the vets. Kayla said that she was more than happy to give the chinchilla the needs and the needs for the chinchilla. And so I trusted Kayla with the chinchilla. When Kayla said that the chinchilla was doing worse, I asked to take the chinchilla to the vet. If I can't do it, could she take her to the vets, him to the vets, and neither was done. And the result, the chinchilla passed.
Okay, and the other 2, she has 1.
She sold the other.
She didn't, she rehomed the other.
Yeah.
Okay, got it. So you're seeking possession of 2 chinchillas. and 3 sugar gliders.
Ma'am, if I could speak for just 1 second.
Okay, give me just a moment for the total value of $750. Can you reprint the scale complaint form for claim and delivery so she can file it? And then actually, let me just cross it out and put it in. Huh? Yeah, I want her to file an amended complaint today. You received the complaint, looks like on September 30th, it was signed. I don't, let me see when it was served on you. I don't see a proof of service, but you obviously moved up here today. Do we have a proof of service in JIS? Because you're gonna have to respond, and you can respond in writing to the complaint. And we're gonna have this set for a pretrial at some point so that we can get the ball rolling on this as quickly as possible.
I do want
Yes.
to bring one concern to the plate. The reason why she's saying that she had to file a motion for the animals is absolutely accurate. So I've been in contact with her old co-op, who I actually went and retrieved the animals from while she was on vacation or holiday. She had asked me to go retrieve the animals. I was in the assumption thus picked up 2 sugar gliders. I ended up picking up 5 sugar gliders. A whole big mess. I was told that she was not allowed to have uncaged animals, or she could have caged animals with approval. I had asked her into her new housing that she just went into. I asked her that I speak, that was part of our agreement, that I speak to the housing agency. And she proceeded to tell me that it's ran by a bunch of kids and they can text me via her phone, which also, again, I'm like, I want to talk to whoever the housing is. I can come there, like, I just want to make sure that the animals are going back into a proper thing. She's also had about 6 animal control cases in the last year and a half. I don't know if that's relevant. She has one currently. She was just investigated a few weeks ago. I did request it through animal
That's
control.
not before the court.
Okay. I didn't know if that'd be relevant to the situation.
It's not relevant. Today, we're only here for possession pending
Correct.
judgment. I'm denying it based on what I put on the record.
Okay.
As to whether or not it's relevant to the underlying case. I don't think whether or not she had open or pending animal control cases is relevant to whether or not you were supposed to return these after the care that was given. We just want to get to the bottom whether or not you were supposed to provide care for a reasonable time period, and if that time period was expired, what you did with the animals reasonable. And so we can do that in the underlying matter. There'll be a period of time in which, if necessary, you all can engage in discovery, because it sounds like you have some exhibits or information that you would like to present as part of your defense to her claim. You would need to provide her all of that information prior to.
It's public knowledge. I got it also.
This is not.
Oh, okay.
No, you would need to provide it if you want to use it in court.
Oh,
You have
I'm
to-
sorry.
yeah,
I'm not
that's
really
what I'm
sure
telling
how
you.
that works.
Yeah,
Okay.
that means if you want to use it and present it as an exhibit, which is that what you would do,
Okay.
you're gonna have to put her on notice as to what you're using so that she knows what you have there. So
Okay.
it'd just be a copy of it that you would need to.
I can actually provide that for you right now.
You have copies of all that
I do.
information. If you have copies of information that don't have any writing on it, that's what the court would
Yep, those
prefer.
are
Okay.
copies. I have.
And
the
then
other
same for
copies.
you, if you have information that you would want to use in your underlying case, you would need to also provide that, but you all will have a formal discovery period for that. But you need to file an answer to her complaint first, okay?
What do you mean?
You're representing yourself, you're gonna have to get some court rules, man.
I'm so sorry.
You don't have to be sorry, I recognize that
I've
you're
never been in this
self-litigating.
situation. I'm not
But
sure
yeah,
how to respond.
when someone serves you with a complaint, which is what you got, it tells you on there, you gotta respond.
Do I say
And it
like-
tells you how many days you were supposed to respond by. And it said, yeah, depending on how you were served. I don't have the proof of service in the file. Is there one in there?
I
Personal
have
service.
it.
It says there was some personal service there. You were supposed to. Says on the bottom, you have 21 days after receiving the summons and copy of complaint to file a written answer with the court and serve a copy on the other party. You get 28 days if you were served by mail or outside the state. It says that on there. Did you read that?
I did. I guess I didn't understand what that meant.
Or you didn't understand that you need to do a written copy, a written answer
No,
somewhere?
I did not.
Did you call anybody and find out?
I did actually. I've been to the clerk's office and I called the clerk's
And
office.
what did the clerk's office say?
I never got any of that
They
information.
would've
They
told-
just, They just told me what the court date was for. Essentially, I guess I didn't dig deep enough to ask.
Yeah, you don't have to dig that deep. You just have to be clear of what you're asking for. They could have been giving you an answer form that you write out your answer, write your answer right on there. You should probably leave here today and go and get one.
Okay,
And then you would file it on and follow those rules.
okay,
If you have any other questions, you're gonna have to get a copy of the Michigan court rules, or you need to counsel with an attorney. Because unfortunately, even though you're representing yourself, you're still held to the rule of law.
okay.
And so I can try to be as flexible as I possibly can. For example, I'm not going to penalize you for going beyond the timeline at this point, specifically because we're amending the complaint. So it's almost like you're gonna get a new complaint today anyways. So we're gonna have this complaint amended now to reflect the updated allegation of the return of 2 chinchillas, 3 sugar gliders, estimated value being $750. And you'll get a copy of that. I'll have you sign it. I'm gonna write it in here for you.
So the next pre-trial, this is when I would give examples or proof.
No, our pretrial will typically, will only be for the purposes of you all coming to a joint pretrial, appoint a joint pretrial statement, which you could do it today since you're both here.
Yeah.
And that'll avoid that. We can get Mr. Bigelow to put you in a private meeting room and give you the documents to help you fill that out. And then we can get that taken care of. That's what kicks out.
Okay, so do you want this proof then?
I can't take any proof.
Okay.
Today, you reserve those proofs for when you're ready to have your trial. She's gonna file a response, because she's gonna get it. I think I just gave you something to sign. Did you give it to her?
Yes. No, yes.
Yeah. Yeah, I need you to sign that.
Okay.
And then we'll get it in here as an amended complaint. We'll get you a copy of that. You need to respond within 21 days, okay? In writing, but you should go down to the clerk's office and get the form so you can do that immediately. Because I know what happens during the holidays. Everybody forgets all the civil responsibilities they have, and then they're crying and they get a default judgment in the fresh of the year, and we don't want that for you. So can we get her a pen so she can sign that? Any questions for the board today? Okay, we'll get you in a private meeting room so you all can work through the joint pretrial statements. If you have any questions about what any of those sections are, Mr. Bigelow can make sure the court is here to address that for you. And then we can get that taken care of now. That avoids you having to come back for another court date just to complete that. That's what we use to kick out your scheduling order, okay?
Okay, so we're going to meet in a room.
Yep, and you're just gonna go through that to fill in the information. So for example,
Okay.
it's probably the first thing is about pleadings. Pleadings would be your answer, your complaint and your answer. She hasn't filed her answer, she's gonna file it
Yes, ma'am. Today.
today. And so you can put that those would be in order. There's no issue or discrepancy as to the pleadings at this time. Whether or not you want a jury trial, if you haven't filed a jury demand. When you file your answer, if you want a jury trial, you have to demand it in your answer. I don't think this is the case that warrants bringing in a jury, but it's not up to me to decide. That's up to you to decide. And so you have to put in that paperwork, and then you want to put how long you estimate the trial to need. I think a trial like this needs 2 hours max. Probably needs 30 minutes, but I like to give people time to ramble on and get it off their chest. And so you would put half day, something like that. Discovery just means the time period in which any evidence you want to use and present to the court, that's discovery. Or if you think she has some evidence that you don't have, you want to request it from her, that's what discovery is.
Okay.
So you would put, you don't even need to fill that in, I can fill it in for you, but that's what it is. If you see discovery, I'll give you a reasonable time to get that taken care of. And then whether or not you think this matter can be resolved via mediation or something like that, there's a question on that. But any questions you have, if it's not answered by that sheet in front of the document, then the court is here to answer it for you, okay?
Okay, and then For the amended paper, what do I do with
You
that?
signed it?
Yeah.
Okay, you can give it to Mr. Bigelow. He's gonna get it to me. We'll get you a copy for both of you.
And what is the judgment on, is there a judgment on that or? does
This,
that have to
no,
go
this
through-
is your original complaint that you
Yeah.
filed. We're amending it.
Right,
We can't make a judgment until we haven't done the case yet.
okay,
Today was only for, you wanted possession pending judgment. I've denied possession pending judgment. There's only one animal she has anyway.
yeah,
So I've denied it because I don't think you provided me with sufficient evidence to grant you possession of that one animal because she believes it was given to her. And I can't determine that until the time of the trial for the underlying matter, okay?
okay, thank you.
No problem. Do you have any other questions at this time?
Yeah.
It's warm in here, or is it just me? Okay, that's what I thought. And we're putting Mr. Bigelow to work, but we're gonna get that fan on there. Thank you, sir. You don't want me melting up here. Okay, and let's see. No questions? We can get him in a private meeting room. We're off the record on that matter. Okay, Mr. Dax, you had a 3 o'clock with Calvin Scott. I do see Calvin Scott here.
Yes, Your Honor, we went into a breakout room. We have a consent judgment to enter.
Mr. Scott, can you please start your video? Mr. Scott, are you there? Mr. Scott might have stepped away. Oh, okay, very good. We're on the record in the matter of Sycamore Townhomes versus Calvin Scott III, file number 22-02077 LT. Council appearance for the record.
Correct dates on behalf of Sycamore Townhomes.
Okay, Mr. Scott, can you hear us clearly?
I can. I was on the break. Everybody's going on break, so it's kind of loud here at my job. But I can hear you. I can hear you probably better than you hear me.
Yep, this was a court date, so you were, one of the requirements, if you were going to appear virtually, was that you needed to be in a place where you can hear and proceed with court. You understand that?
I apologize, Your Honor. I was in the break room and everybody went on break. Everybody came into the break room. Okay, I'm coming. I'm in the bathroom now. I'm in the bathroom.
I don't know if you can find another location, but as long as you can hear, we're fine. It sounds like you all have come to an agreement. Is that correct?
Correct.
Okay, can you place the terms of the consent judgment on the record, Mr. Dax?
Yes, Your Honor, the amount of rent owing is $7,019.06. We would add other money owed, which would be December of $740 plus court costs of $155 for a total of $7,914. We gave Mr. Scott until December 31st of 2022 to get that balance caught up. No money judgment. He understood his rights under Michigan court rules, and he gave me permission to sign.
Okay, Mr. Scott, is that your understanding of your consent judgment?
Yes, ma'am.
Okay, the amount is what you remember the amount being. You're not disputing that amount?
No, ma'am.
Okay, you understand that there's a writ date of December 31st, correct?
Correct.
You have the right to be represented by an attorney during this eviction proceeding, and you have the right to proceed to a trial. You would have to waive both rights if you want to enter into this consent judgment. So do you want to waive your rights today, sir?
Yes.
Did anybody threaten you to get you to waive those rights and enter into this consent judgment?
You said one more time?
Did anybody threaten you? Like, did Mr. Dax
No, ma'am.
threaten you to waive your rights
No, ma'am.
today?
No, ma'am.
Okay, and you're waiving your rights freely and voluntarily, correct?
Correct.
Okay. You have 3 business days from today. If you leave here and later determine that you misunderstood the rights that you just waived, you can request to have this judgment set aside. You would have to articulate or explain to the court why it was or how it was that you misunderstood your rights, okay?
Okay.
Okay, and then you can request to have that judgment set aside. You're giving Mr. Dax permission to sign the consent judgment as what he stated on the record today?
Correct.
Okay, do you have any questions today?
I do have a question, Judge Simmons.
Yes, what's the
This is
question?
my second or third time looking at your courtroom, and I see you have, I'm not sure, assistants or someone to your side, to your right, two people. And I'm happy about that as well. I'm not sure, but thank you. And I also want to say Mr. Rosa is excellent.
That he is, indeed he is. I will make sure I pass on that compliment. And I'm not sure I understood the question, but yes, the immediate to my right is my wonderful judicial assistant. Today is her birthday, by the way. And then my intern is all the way to the furthest part of the right. But thank you, sir.
Well, I'm going to some kind of way invite you to one of the plays that I've written, okay? And I'm gonna send you the book. I've tried to send a book to Mr. Rose, but I'll send a book to you and invite you to a play. Right here.
Okay,
Well,
we're happy to support any local arts here in Lansing. So good luck to you, okay, and happy holiday.
Thank you. Same to you.
Thank you, Mr. Scott. Thank you, Your Honor.
Thank you, Mr.
Thank you, Mr. Dax.
Dax. Okay. So I can go ahead and leave because they need me out there.
Yep, you need to go back to work, sir. Thank you. Okay, Ms. Till is here. I know I see Victoria Arambula present. And then I see Stanley Meyer. Did the parties need to speak privately at all?
No, Your Honor.
Okay, let's see who we have here. I'll call you later. Okay, let's see. There should be a motion, is that correct? Okay, we're on the record in the matter of Stanley Meyer versus Alejandro Arambula. And this is file number 22-02196 LT. Council appearance.
Felicity Till, P83961, appearing on behalf of the defendants Alicia Arambula Gonzalez and Alejandro Arambula, who are present with me via Zoom.
Did I get a judge's copy of this? I need one to mark it up. Okay, and then Mr. Meyer is present today, and you do not have an attorney, Mr. Meyer, correct?
No, I do not, Your Honor.
Okay, today was the date and time set for a hearing on a non-payment of rent. However, defense counsel has filed a motion for summary disposition. Mr. Meyer, did you get a copy of this motion?
Yes, I did, Your Honor. I was reviewing it yesterday.
Oh, okay. So you have not filed a response. Did you need time to file a response or get an attorney to file your response?
I did speak to an attorney yesterday, and he said I am good for the motion to dismiss without prejudice.
What does that mean? You're good.
I'm okay in agreement with Felicity's motion to dismiss, but without prejudice.
Okay,
I know she
so
filed a
you're not-
motion to dismiss this, and then I'll have to refile, obviously. Yep, I'm
Okay,
aware
so
of that.
you have consulted with counsel, you're not in dispute with the position, and you are stipulating to this dismissal, is that correct?
Yes,
Okay, very good. Then a motion to dismiss without prejudice is granted based on the reasons stated in the motion. Ms. Till, did you provide me with an order?
I did not, but I can send a dismissal to your courtroom post haste.
Wonderful. Thank you very much. With that being said, this matter will be dismissed without prejudice. We'll get you a copy of that order under the 7-day rule. Okay, Mr. Meyer?
okay, thank you.
Okay, thank you. Any additional matters for the record today, counsel?
Nothing for defendant, Your Honor.
Okay, anything for you, Mr. Meyer?
No, Your Honor.
Okay, you're all set. Thank you, sir.
All right. Thank you, Your Honor, and happy birthday to your judicial assistant.
Thank you. Thank you. Have a good one.
You too.
Thank you.